Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group, and Ludka Zimochak, also one of the managing attorneys at NPZ, is here with me today. And we, as everyone knows, have offices located in New York, New Jersey, Indianapolis. We also have a presence in India and in Canada. And we have Canadian immigration lawyers on our staff to assist you with any questions you might have with regard to Canadian immigration law. Specifically today, though, Ludka and I want to discuss a legal standard called extreme hardship. And actually, this segment, this video, should probably be viewed in tandem with the discussion that we recently had about provisional waivers, because the legal standard for being able to obtain a provisional waiver is extreme hardship. And recently there was a memorandum that came out from the government that described what is considered to be extreme hardship. Ludka, maybe you can tell us a little bit about your view. Obviously you do a tremendous number of waivers here in the office, and you have not just an academic view of extreme hardship, but you also have a very practical view of extreme hardship, as do I. I mean, we always look, I guess, first at what it means academically, but then we also have to translate that practically into the person's life. So how do you do that? Tell me a little bit about that.
Well, first of all, there is no definition of extreme hardship. It's just based on the case law, and whatever the proposed rule is, it's not really anything new for us, because again, right, it's just coming from the case law, and it discusses the totality of the circumstances. So I feel there is not much new as far as the extreme hardship. There are not many cases with great hardship cases. That's why totality of circumstances is the key. To look
Right.
at medical grounds, to
Right.
look at financial problems of the family, on the qualifying relative, of course, to look at the children, even though they are not a qualifying relatives, but it's important to look on the indirect hardship to the qualifying relative. Also look
Exactly.
at the political situation of the foreign country. So it's super important to look at the totality of the circumstances, and that's basically what the expansion rule talks about.
Exactly.
They want to look at the totality.
Exactly, but I think that memorandum which came down actually sort of solidified, like obviously we were always trying to argue the indirect
Yes.
Value of the hardship. And I think that this memorandum was helpful because what it did is it solidified for us that looking at the indirect hardship is actually legitimate. It's okay to do that. And
Which is
so,
normal.
Right, but
Because if you have a qualifying relative that is a U.S. citizen who has a child that has a special needs, for example, while the child is not a qualifying relative, but there would be a hardship to the U.S. citizen because that U.S. citizen needs to take care of the child and would not be able to do so without a husband.
Exactly, but I think that what might be obvious for you and I may not necessarily be obvious for people who are looking to try to prove it. If you look at the legal standards or the definition, then what they're doing is they're looking at words and not, again, like you and I understand the practical aspects of how this potentially affects a person's life. One of the other things which you mentioned, which I think is really good, is also that there's a cultural issue
Yes.
that creeps into extreme hardship. And that is, for example, we recently handled a matter for an individual who was a black American who was marrying an Indian. And so there are cultural stress that's put on that type of a relationship, and that obviously is something that creeps into the hardship calculation. So I think that obviously Luke is pointing out that it's a totality of the circumstances, and I think that that's really the takeaway. The most
Yes.
valuable takeaway is that it's a totality of the circumstances.
And another important point is that many times we try to argue both sides, because you have to show
Exactly.
what is the hardship to the U.S. citizen if the spouse leaves the United States, and what is the problem, why the United States citizen cannot just go and leave the United States and stay in a foreign country. the USCIS or the government, they want us to argue both sides, and that's very important.
Exactly, and that's where the country conditions can be critical when you make that argument, taking into account what the country conditions are and how they may impact individuals who are going to be potentially resettled in that country. So those are future arguments which we try to make. The extreme hardship, as Ludka pointed out, the extreme hardship doesn't really have a definition, although it is subsumed within the case law. However, we'll point out that in November of 2014, President Obama did make an announcement that he was seeking clarification of what is considered to be extreme hardship, and he did promulgate, he actually pushed the USCIS to promulgate a memorandum, and that memorandum is out there, and it is obviously a nice roadmap, although probably not exactly the end-all be-all, because there are so many additional nuances that creep into that memorandum.
And it is a discretionary matter.
Always discretionary,
Yeah.
exactly. Exactly. So if you or any member of your family, friends, your colleagues have any questions with regard to the definition of extreme hardship or how it might impact upon you, at least with regard to how you're going to do a waiver case, please feel free to give us a call at the number on your screen, or you can send us an email. We'd be more than happy to assist you. Thanks very much for being with us.
Thank you.